Hi there, it's Azilia here from Tax World. Today I'd like to talk to you about a decision of the Upper Tribunal, Tax and Chancery Chamber, in the case of HMRC versus Suterwalla concerning stamp duty land tax, SDLT. The case involved Mr. and Mrs. Suterwalla's purchase of a property in December 2020, which included a house with gardens, a tennis court, and a paddock. The Suterwallas filed an SDLT return declaring the property as mixed use, residential and non-residential, resulting in a lower tax rate. They granted a grazing lease for the paddock on the same day as the purchase completion. HMRC challenged this, arguing the entire property was residential and thus subject to a higher SDLT rate. The First-tier Tribunal, FTT, initially ruled in favor of the Suterwallas, considering the paddock as non-residential due to the grazing lease. HMRC appealed to the Upper Tribunal, UT, on 3 grounds, mainly arguing that the FTT erred in considering the grazing lease and in concluding the paddock was not part of the residential property. The UT dismissed HMRC's appeal, finding that the FTT was entitled to conclude the paddock was not part of the grounds of the house, even without considering the grazing lease. The FTT's decision was based on multiple factors and was not rationally insupportable. The UT discussed various legal principles and precedents regarding the definition of grounds for SDLT purposes, emphasizing that each case must be considered based on its specific facts. The decision upholds the importance of the FTT's role in evaluating facts and making judgments in such cases, with the UT being reluctant to interfere unless there's a clear error in law or principle. This case provides important guidance on the interpretation of mixed-use properties for SDLT purposes, particularly regarding the classification of land adjacent to residential properties. I hope you found that useful, and I'll see you in the next video.